I am really delighted to introduce our panelists. Many of you are already familiar with them, both longtime members of Christian Legal Fellowship. We have Adrian Miedema, who is a partner at Dentons and who hosts many of our Toronto chapter meetings. Adrian will be sharing a little bit from the employer's side, or the employer's perspective of some of these issues. And we also have Ryan Watkins, who's a partner at Whitten in Lublin, and Ryan is also a longtime friend and member of CLF, who represents both the employer and employee side. For the purposes of today's webinar, we've asked Ryan to share primarily from the employee's perspective of some of the issues that we're talking about today. So I'm very pleased to introduce them and hand it over now to Adrian. Again, as Sarah mentioned, if you have questions during the webinar, please do type them into the Q&A box, and we will have a time for Q&A at the end to present all of your questions to our panelists. So with that, Adrian, over to you.
Thanks, Derek. You can hear me, I assume, Derek?
Yes, we can, Adrian, loud and clear.
All right, thank you. Thanks, Derek, for your introduction and for your words on compassion and justice, which I think are very important at a time like this. And also, it's a pleasure, Ryan, to be co-leading with you. And if I can, just for a minute, just to follow up on what you just said, Derek, I was thinking the other day about the sort of virtues that we are to hold as Christians, and about the so-called cardinal virtues that go way back to the time of Socrates and Plato, and then into the Christian tradition through Saint Augustine and some of the other early teachers. And it seems to me that these sorts of virtues are the ones that we, and Derek talked about some of them, are exactly the virtues that we should be showing as Christians. The cardinal virtues of prudence or wisdom, justice, fortitude or courage, and temperance. So wisdom, justice, courage, and temperance have been the cardinal virtues for thousands of years, held by different traditions, and certainly the Christian tradition. I think these are all things that we as Christians should be thinking about and striving to exhibit, especially at a time, such an unsettled time that we're in right now. Wisdom, justice, courage, and temperance. The other thing is the theological virtues of faith, hope, and love, and we'll, I think, be reflecting a little bit on that in our talk today. If we could hold to those virtues, the theological virtues, faith, hope, and love, and the cardinal virtues as lawyers as we go through this time, I think we will, and rely on God's Spirit to support us, and on the support of each other, I think we will be doing well. So I just wanted to open with that quick comment. And to follow up on the topic of compassion, so at a time like this, again, where we're so unsettled as a society, people feel so disoriented, I really believe that Christians, and in particular Christian lawyers, have the opportunity, and I think the mandate, to be a presence of compassion at a time like this. And as lawyers, I know we're not, our licensing is not to provide moral guidance to others, but I think we all know that as lawyers, when we advise clients, there is the legal element, and obviously that's key to what we do, but often the kinds of questions that we come up with involve issues of how people are treated and the morality with which people act. And I've always taken comfort in the fact, and in my own view, that often for us, employment lawyers in particular, what is moral and what is right is often what is the best legal approach at the same time. So treating people well, treating them with respect, supporting them as much as one can, even from an employer's perspective, is not just the right thing to do when you can do it, but also I think often the best legal approach. So I just wanted to open with that quick comment. And then Sarah, if you could move on to the next slide first. So I'm going to talk quickly about each of these items, an employer's options at a time of public health and economic crisis that we're currently going through. Let's hope it's as short as it can be, but we are going through it. And I listed a few. This is obviously not comprehensive, but a few things that employers, a lot of our clients are thinking of: permanent terminations, temporary layoffs, pay cuts, reduced work week, like a 4-day work week. I put a question mark beside those because all of them come with some legal risk. Then there are things like the employment insurance top up or sub plan, where employers can top up employees' wages when they're on EI, subject to certain conditions. Something called work sharing, which I'll explain, and then something called working on claim. And these are just different different things that a lot of employers have had to work through and make decisions about how they're going to manage their workforce. And frankly, for many, including charities, it's not a question as to whether they do something. They have to do something because their business is quickly running out of revenues and running out of cash, and they have to do something. And so they're asking, what can we do that is best for our people and best for our business? So oftentimes it's in my practice, at least right now, these are the employers are saying we have to do something. What are the options and what can we do? So I listed a few options there. So we'll work through them on the next few slides. Sarah, if you could advance to the next one. So the first one, permanent terminations. I've actually had very few clients that have done permanent terminations during this time of the COVID pandemic. Largely, I think because most employers they put a lot of effort into retaining people, and they hope that this is over soon, and they hope that people get back to work, and they don't want to lose their colleagues. And so permanent terminations, generally speaking, we're seeing less of that. I'm seeing less of it in my practice. And the other thing to keep in mind about permanent terminations is both under statute and common law, if you're to terminate somebody's employment permanently, you're going to owe them a package of some sort, could be significant at common law. And so a lot of employers simply don't have the resources to pay out liability, which would be immediate liability for termination and severance if they were to terminate. So obviously, as you all know, this is an option that's available in the vast majority of non-union workplaces in Canada. Not everyone in the federal jurisdiction. There are some job protections there, but in all the provinces, in almost every case, this is available, but an option that's not being used very much right now. If we can move on to temporary layoffs. So this is really the hot topic, I think, in the employment bar, at least the management side employment bar right now, is temporary layoffs. In the past, we found very few of our clients would, in the non-union, and I'm focusing on the non-union work environment, very few of our clients would engage in temporary layoffs during good economic times. They just generally don't do it. But here, because of the sharp contraction, how quickly this has happened, and the desire to preserve their workforces, almost every business is thinking about temporary layoffs of some sort or another. So very quickly, temporary layoffs are in general permitted by labor and employment statutes across the country, provincial statutes. BC has some fairly significant restrictions, but all of the other provinces allow for temporary layoffs under their Employment or Labor Standards Act. But they also, almost all of them have limits on how long a temporary layoff can run before it triggers an automatic termination. So Ontario, for instance, it can go up to 13 weeks, or if you continue all benefits, it can go up to just under 35 weeks. Alberta, the layoff can be 60 days within a 120-day period. Saskatchewan, 12 weeks within a 16-week period. And then Quebec can go up to 6 months. So it varies by province as to how long the temporary layoff can run before it triggers an automatic termination. But here's the big but, and I know Ryan's going to talk about this. The case law says that unless the employer has a written contract or an agreement with the non-union employee that allows the employer to put them on temporary layoff, the temporary layoff will be a constructive dismissal. So this is really the big legal issue that we're dealing with. Can employers do temporary layoffs, even though they're permitted by statute that there'll be a constructive dismissal at common law? But in my experience, and I think just working through, and this is, I think, a very important point, working through the realities of the situation that we're in. Number one, are most people going to give up their job if they're put on a temporary layoff? And again, temporary is key for a short period of time. And file a claim in the courts that are probably closed in their province and will be quite backlogged. The claim will take a long time. They're going to have to retain a lawyer, pay legal fees. And where they would have a job available for them in a few, let's say, hopefully weeks to come back to, are most employees going to give up a job when the unemployment rate is spiking to take their chances on a constructive dismissal lawsuit? I would think probably not. Most aren't. Some might, but most aren't. And the other thing to keep in mind is, even if the person were successful in a constructive dismissal lawsuit that gets heard 2 years from now, likely the employer would have a good argument that they failed to mitigate by leaving their job. They should have stuck around and come back to their job after the temporary layoff. So that would mean that their damages would be limited to the amount of pay that they lost during the temporary layoff, and they wouldn't be entitled to full severance. So that's something that I think employees and employers have to keep in mind. A lot of employers are going ahead and doing it, realizing it's a calculated risk, but saying that this is what we have to do in order to survive and preserve our business or organization. So a lot of employers are doing it. The last thing I would say, and very importantly, I think on temporary layoffs, is I've always said to clients, take some time and put some effort into showing compassion, showing empathy. Tell the employee in the letter why you're doing this, why you have to do it, the impact on your business of the COVID-19 emergency and pandemic, how you regret to do it, you hope it's short term. I think showing compassion, showing empathy, showing care, offering to continue benefits, offering to continue employee assistance plan, confidential counseling services, if you have it. I think all of that is very good just to help the employee, but even legally put you in a better position if this gets scrutinized in front of a judge. So show some empathy and compassion in the temporary layoff letter. And the next slide, please. Thanks, Sarah. Pay cuts. So the issue with pay cuts is usually how large of a pay cut can an employer make before there's a constructive dismissal. And obviously you have to look at the employee's contract to see what it says about salary and wage levels and whether the contract prohibits a pay cut. But generally speaking, it appears from the case law that a wage cut of, let's say, less than 10%, especially if it's temporary to deal with the economic circumstances, probably not a constructive dismissal. 10 to 15%, you're probably in the yellow zone, and above 15%, often the courts have said it's constructive dismissal. Obviously, we know as lawyers, you have to consider all the circumstances and look at all of the facts, and you can't just say there's a threshold at 10 or 15%. But I think largely on our analysis, that's how the constructive dismissal cases sort of end up. But again, you could say, okay, so if it's more than 15% and an employee can claim constructive dismissal, practically how many people are going to do that? Again, they have to give up their job, they give up their income, or at least 85% of their income because they've been cut back 15%. They have to get a lawyer, pay a lawyer, file a claim, take 2 years to get heard, and then be stuck with their damages being limited to the amount of the pay cut for whatever period of time, not their full severance in light of the fact that they had a job that they could have gone to. So it's an option that does pose some legal risk, but I think we always have to ask our clients who know their employees better than we do, do you think that this poses a practical risk, or are most of your employees going to stay around? In fact, I've had a number of clients, including one just this morning, that said employees came back and said, thank you so much for keeping our jobs and not terminating us. I'm so pleased to have a job, even though our salaries have been reduced across the board, but I'm grateful to have a job. So we are hearing that. All right, next slide. A reduced work week is another option. It's similar to a pay cut, of course, but the person is working less. So a 4-day work week, for example, which is and paid on the basis of 4 days, which would be a 20% pay cut, of course. That is likely in the constructive dismissal range because it's 20% less pay. Will employees leave and sue over that? Again, we need to ask that practical question, I think, of whether employees will indeed leave and sue over that. Now, there is one case while we're talking about pay reductions from Ontario in 2010, the Ontario Superior Court, called Russo versus Kerr, the Kerr Candy Company. And in that case, his salary was just a one-off. His salary was cut significantly, I think 35%. He brought a lawsuit. He stayed with the company, brought a constructive dismissal lawsuit. The court said, yes, you can advance a constructive dismissal lawsuit while you're still with the company. And he stuck around to mitigate his damages, and he was awarded damages of the 35% delta, the drop in his pay over the period of whatever his notice period is. So that is a possibility that employees could do that, even if you cut back their pay and they don't immediately protest. There's always a possibility of a lawsuit. one would question how many employees would be sort of gutsy enough to sue their employer while they're still there, but it's always an option. And next slide, please, Sarah. So the next one is going to be EI top-up, work sharing, and working on claim. So there's a number of programs, and many of you will have already read about some of these. The EI top-up means that the employer, if you register what's called a supplemental unemployment benefit plan, and get it approved by Service Canada, and your employees are out of work collecting EI, you can actually top up their wages to a total of 95% of their normal weekly earnings. So the employer would pay some and EI would pay some to keep the person close to whole 95% of their earnings. You do have to fill out an application and register it with Service Canada. The second one, work sharing, this is when there's a shortage of work in a class of employees. So if you've got a group of 20 employees that do the same thing, the work has shrunk, you've only got work for 10, you now have them do two-day weeks or something like that, or 3-day weeks, and then you share the work amongst the different workers, and then you register. Again, you have to register a work sharing plan with Service Canada. They have to approve it. It takes about 30 days, whereas the sub plans, the top-up plans, are much quicker, sometimes 3 or 4 days. And you also have to get the employee's agreement to work under this work sharing. But what it does is it allows the person to get their wages for, let's say, 3 days a week if they're working 3 days a week, and then EI on their wages for the other 2 days. So for Thursday and Friday, they'll get 55% of their wages from EI, up to a maximum of $573. For Monday, Tuesday, Wednesday, they'll get their regular pay from the employer. And then the last one I would mention for EI is called working on claim. And what that means is that employees, if they become unemployed, they're getting EI benefits, they can actually earn income from other sources while they're still collecting EI, and it reduces their, and obviously not full-time or they couldn't get EI anymore, and the EI will reduce their EI benefit by 50% for every dollar that they earn from their other employment while they remain unemployed. So that's just a way for an employee to earn a little bit more money while they're unemployed. The next slide. Government benefits and support, many of you have heard about these already. There's still a lot of, we're still waiting for a lot of detail. EI is straightforward. That's always been out there. 55% of insurable earnings at the weekly benefit to the maximum of $573 a week. So that's something that someone who's been an employee can apply for that. If you've been an independent contractor, generally you can't. Then there's the new Canada Emergency Response Benefit that was just recently announced. I think probably everyone's heard of that. That is $2,000 every 4 weeks for an up to 16-week period. And this one is broader as far as who can apply. It includes independent contractors, people earning, and also people that are low wage who may not get the maximum EI benefit. It may be actually more beneficial for them to apply for the CERB. And at this point, we understand you can only get one or the other, employment insurance or the CERB, not both at the same time. But if you apply for the CERB, you can still get EI afterwards if you're still unemployed and you have enough insurable hours. Then we have the federal wage subsidy. The details were supposed to come out actually yesterday from the federal finance minister. We don't have those yet, unless it just happened in the last hour or so, which I didn't check. But the details we have so far is that the federal government will subsidize up to 75% of employees' wages, but the employer, based again on the current details, must have suffered a drop in their revenues of 30% or more, which a lot of businesses won't have, some will, but those are the criteria we have. But if you're interested in that, stay tuned to the federal government website. We expect details anytime, possibly even today. And then lastly, emergency daycare. This is something that Ontario has introduced for healthcare workers. So for those in the healthcare field, nurses, doctors, and personal support workers and others, the government's actually making daycare available to them so that they can focus on their important work at this time of emergency. Okay, so that's it for me for now, and I'll turn it over to my friend Ryan for the employee considerations.
Adrian. So I just want to start off by again reiterating the compassion message that Adrian so eloquently spoke about. Uh, this is, a time in our history where globally we're going through something that touches on everybody. Everybody's been affected, whether it's been, losing your job, or family member losing their job, or somebody being ill or sick. And this is a great opportunity for the church to be the light, and be the guiding post for so many people that are going through uncertainty. So I encourage all of our members to, reach out to friends and family members who could be hurting during this time, and simply just send them a message or give them a call to see how they're doing. And oftentimes that can open up to additional conversations where we can spread the message of the gospel. For me personally, I went through a period of during the economic downturn in the U.S. While I was a law student. So I certainly feel for what our law students who are listening today, what they're going through, and just to share just a little bit about my story during the economic downturn during that time period. When I came out of law school, I had a job lined up. So if you read my bio, you'll see I'm called in Hawaii. And so that's why I had a job lined up in Hawaii. And unfortunately, I was deferred for a year. And then after that year, I got a call that unfortunately they couldn't hire me due to the ongoing economic situation in the US. And so during that time, it was a down period in my life. And so I actually came back home here to Toronto, and obviously students there were going through, it wasn't as bad as the US, but certainly an economic downturn during that time period here in Canada. And I found it difficult to find articles, but eventually I did. And I've been practicing for 8 years now. So for the students out there who are worried about their job prospects, and what's going on, let my testimony be a story for you that the same considerations can happen for you too. And out of this, things will be okay, and God will provide and protect you. And so there's going to be plenty of opportunities to be a practicing lawyer and flourish in your career. So I just wanted to put that out there, that even during this difficult time, know that God has your back. Turning now to some employee considerations during this time, I want to touch on four main points. So we're going to talk about, refusing unsafe work, declared emergency leave under the Employment Standards Act, human rights considerations, and some of the constructive dismissal arguments that Adrian touched on with the various mechanisms that employers are using. So we'll talk about that too. If we could just turn to the next slide. So refusing unsafe work. So an employee has a right to refuse work that's likely to endanger them. That's set out in the Occupational Health and Safety Act. So I was getting a lot of calls before there was the social distancing measures put in place by the federal and Ontario government. And I saw a lot more of these type of issues where people felt unsafe to come into work. Now, the majority of us now are working from home, so we don't necessarily have those considerations in place. But it's important for people that are still working in the workplace, because there are some that have been deemed as essential services and still have to come to work. If you feel you're endangered, and that standard can be a little bit of a slippery slope, as most of us as lawyers, the answer we often give to our client is it depends, right? And so it has to be a reasonable expectation of being unsafe. Um, and one of those examples would be if someone around you has contracted COVID-19 and still may be in the workplace or exhibiting symptoms, you have every right as an employee to refuse to come to work under those conditions. So, for us in general or our clients, that's something that we should be advising, that no person should be mandated to come to work. Obviously, there are exceptions. In the medical field, doctors and nurses are coming to work and putting their lives on the line. So obviously, those situations are different. But as a general practice, if you're in an unsafe work environment that's going to endanger you, you don't have to come to work. Lastly, on this point, it's not an unlimited right. So simply when that harm is no longer there, this is not a carte blanche time to take a vacation per se. Once that unsafe work environment is no longer a threat, that you have to return to work. If we can go to the next slide, Sarah. So recently, the Ontario government has come out with a Bill 186 that amends the ESA Section 50.1, which deals with an emergency leave. And so under this section, an employee is entitled to unpaid leave as a result of a declared emergency. And as we know, COVID-19, the Ontario government has declared an emergency in this regard. This is a job protected leave. So your employer cannot reprise against you for taking this leave, and you have to be returned to your position if that position is no longer available, a similar situated position. This leave mainly comes into effect, I think, practically with parents. So parents who have childcare needs, this part of the act specifically addresses that. So if you have childcare needs, and as we know, the schools are closed right now, so a lot of people are having to take care of their children and juggle that with work. And so under the declared emergency leave, parents can take that time off, again unpaid, but to care for their children. Employee benefits must be continued during this time, so employers have to continue those benefits. Employees, if they pay or share a part in those premiums, they would have to continue to provide payment of those shared premiums. The leave under the Declared Emergency Act would end once the emergency is declared by the government to be over. Obviously, with COVID-19, we don't know when that will be. The Ontario government has extended the social distancing measures for another period of 2 weeks. And so we'll have to see where we're at in the middle of the month. But certainly we should be taking our cues from the government with respect to the ongoing threat of this pandemic. Next slide, please, Sarah. Thank you. So there are some issues surrounding human rights. The Ontario commission, Human Rights Commission, has put out a policy position. So this isn't necessarily the law, but certainly a policy position that the commission has taken, that any negative treatment of employees who have or perceived to have COVID-19, that would be a discriminatory act and prohibited under the Human Rights Code. With this, employers have to be mindful of their absentee policies. So anything that would negatively affect employees in this regard with respect to COVID-19 may be seen as discriminatory. Again, parents, this policy position is important for parents because if you have caregiving responsibilities, an employee cannot be discriminated against and must be accommodated up to the point of undue hardship for parents who have child care responsibilities. Employers need to also be mindful and respectful of employees who may have pre-existing conditions and be sensitive to those issues. So a person may not have COVID-19 or a family member may not, but they may be highly susceptible to it based on, for example, diabetes or an autoimmune disease could cause a heightened effect. So employers, where possible, need to accommodate those employees as well. Employers also should give flexible options to the employees. As discussed, most employees are working from home, but for those employees that may not be, this is one of the considerations for employers, is implementing a work from home policy where feasible. Next slide, please, Sarah. So one of the other issues, and probably the major issues that I see, is related to constructive dismissal claims. And so looking at some of the options that Adrian has presented on the employer side of what employers are doing now to try to protect and save their business. And I echo Adrian on this point. I think, for the most part, employers are trying to save their business, obviously for the benefit as well of the employees. I'm not seeing too many employers act in a negative or a nefarious way. Traditionally, I've seen that they are trying to keep their employees' best interest in mind, and so that's good to see, at least in the short term. So one of the measures that employers have been taking is a reduction in pay. As Adrian touched on, there is percentages where courts have kind of given guidance on what would be considered a constructive dismissal from a percentage of pay reduction. So I don't want to go further into that too much, but suffice to say, so I've had a client where the employer has reduced their pay by 40%, and so I'm of the view that 40% would certainly be outside the purview of what's acceptable, and certainly could lead to a constructive dismissal. The question with all of these measures is whether, again, looking through the lens of, is it better to have a job at this time of uncertainty, albeit with a reduction in pay? Is it better to have that than potentially quitting and claiming a constructive dismissal and then not having a job? So that's something that employees certainly need to keep in mind. Reduced hours is another one. Again, we have to look at the percentages. of what the reduction looks like on a 5-day work week. Certainly, if you're reducing it by 2 or more days, that could be perceived as a constructive dismissal. And then the big one, temporary layoffs, and that's what I'm seeing most right now. And so, courts have said if a contract doesn't have a layoff provision in there, there's a potential argument that a constructive dismissal has occurred with being laid off. Now, again, those considerations have to employees have to keep those in mind again, whether this is going to be temporary, and if so, if this is a situation where an employee is going to return to work in a few weeks or a month, maybe it's not the best idea to retain a lawyer, go through the process of filing a claim if you can. Obviously, courts are closed right now, but certainly you can file electronically, but it may stop there until the courts reopen. But is it worth going through that hassle if you're going to be recalled to work? And courts have also said if you are recalled, you have an obligation to accept coming back to work or risk having a mitigation argument. So employees certainly need to be mindful of that. Also, it's important to know that because of these measures being put in place, it's uncertain what judges will do in this situation when you get a constructive dismissal case, say, for example, based on a layoff or a reduction in pay. These are extraordinary times. And so it may be the case where you could see judges giving a little bit more leeway to employers who are in a difficult situation. So whereas normally I would say judges, tend to lean on the employee side, that might not be the case in this situation. What could come into play, though, whether constructive dismissal or an outright dismissal, and I echo Adrian, I haven't seen a whole lot of outright dismissals, I think, because we're just in a state of flux right now. But for example, with outright dismissals, we could see a situation where judges are awarding longer notice periods, given the fact that the work is just not there and the economy it is stagnant right now. And so that's a consideration, I think, as this moves forward, as we get out of this kind of temporary period. I could see a few months down the road, if the economy hasn't rebounded like we hope, we could see a lot of these temporary measures turn into permanent ones. And then what does that look like from an employee perspective in terms of a notice period? That's going to be something that we need to continue to watch. I just want to touch on, and I don't have a slide on it, but one of the options available, and we've talked about the Canada Emergency Response Benefit. Another option, we've talked about regular EI, but there's also sickness EI available to employees, and the government has waived the 1 week typical waiting period. So there's no waiting period. So an employee can get, if they've been sick or caring for somebody who has been sick, they can get up to 15 weeks of sick EI. And so that's another option available. That's it for me. So I'll turn it back over. I think we have some time for questions.
Wonderful. Thank you so much, Ryan and Adrian, for those terrific presentations. And we do have a number of questions that have come in. And those of you that are listening, please feel free to type your questions in the Q&A box. A number of questions, Ryan, you've already spoken to, and that's the question of, do these current circumstances lean in favor of a longer notice period than under ordinary circumstances? And so is it your view, and Adrian would welcome your thoughts on this as well, is an argument to be made that the notice period should be longer because of the difficulty in finding alternative employment or attending interviews now? Any thoughts on that? And before you answer, I'll just give the caveat for our speakers that questions that come in, obviously nothing that's being shared can be considered legal advice, and obviously a lot of questions will need some specific context. So what's being provided here is purely for general information purposes only.
Yeah, I think that we will see longer notice periods, and again, that's just anecdotal at this point. But I would rely, certainly when would be arguing a case on the notice period, I would rely on some of the cases that have already been decided with respect to the time period when the dismissal happens. So there's cases out there where dismissals during the summer or during the Christmas holidays, and when people aren't generally hired, there have been cases where the notice period has been extended. So certainly I'd make that argument. Whether that ends up being the law of the day is uncertain, but I'd make that argument.
And Derek, I think it's, I agree with Ryan. I think that's an argument that will be made, and that there's support in the case law that if you're looking for a job at a time of a high unemployment rate due to whatever reason, in our case a pandemic, in other cases a recession of the typical sort, that is a relevant factor that the court can consider in deciding what the notice period is, and would tend to lengthen the notice periods.
Sorry, need to unmute myself there. Thank you both. There's some questions here about EI. Question, for example, about can an employee continue to earn wages if they have to reduce their hours to part-time while also receiving EI?
Ryan, you want me to handle that one?
Sure, go ahead.
So for EI, the general rule is that you have to be unemployed and not earning wages in order to qualify to start receiving EI, unemployment benefits. The two options that I talked about are EI work sharing, where you're working reduced hours, but your employer has registered a work sharing plan with Service Canada, got approved, and you agreed to it. Then you can get EI for the days of the week that you're not working because of the work sharing arrangement. So that's a way to sort of supplement income. And then the other is the working on claim program, which just allows you to, again, you become unemployed, you're not earning any income, you go on EI, and then you start earning income from other sources, and they'll deduct 50 cents on the dollar of that income that you earn, but you'll still be able to keep the other 50 cents. So again, that helps to supplement your income.
Thank you, Adrian. And is that also true of the emergency benefits, so the new $2,000 a month Canada Emergency Benefit? Does that only apply if the recipient has no income whatsoever, or can it apply if their income has been partially reduced?
There's not enough guidance, Derek, but my understanding is that you would have to be without any income in order to apply for and qualify for the CERB. The rules may change, we don't have them yet, but I think you have to be unemployed with no income.
Great, thank you both. A question here about what to do in the context of an employer becomes aware that employees are not engaging or following social distancing guidelines, and maybe aren't even doing it in the workplace, but are just aware that they're doing it outside of work, and there's a concern about their behavior in that regard. Any guidance there on how an employer should deal with those sorts of questions?
Ryan, you want to handle that one?
Sure. So certainly there are situations where conduct outside of the workplace could could lead to a cause termination as one of the options. I'm not sure if employers policing social distance guidelines outside of the workplace. I don't know if that would lead to a just cause termination. Certainly an employer has the right to let an employee go for any reason except for a bad reason like discrimination or something like that. But I don't know if we're talking, is that enough for a just cause termination? I don't know if that would fall under that. What are your thoughts, Adrian?
Yeah, I agree with that. I would say though that leaving aside the termination issue, that given that this pandemic seems to be, at least at present, getting worse, and let's hope it gets better soon. But the Ontario numbers where we are here came out today, and there was a pretty high number, I think 400 some cases today in one day of new positive tests. So if this continues to worsen, then it would strike me that it's a reasonable rule for an employer to impose, especially if you work in a nursing home, a hospital, something like that. That it's a rare situation. And I agree with Ryan that generally employers can't impose rules on people's private lives, but to the extent that it impacts the workplace and especially vulnerable people, I think an employer could impose a rule in these circumstances. You're required to self-isolate on your off hours. I know that seems harsh, but I think it's becoming increasingly clear that that's necessary for health reasons for all of us to do it, and certainly healthcare workers or anyone working in a plant. And if employees were violating the social distancing, requirements, that I think an employer could talk to the employees about it. I agree with Ryan that ultimately, is it going to be cause for dismissal? Probably not. But it seems to me a rule or guideline that an employer can impose, in the circumstances.
Wonderful. Thank you both for that, for those answers. Some questions about the wage loss subsidy. And I know that we don't have a lot of information on it, so this may just be something that we just have to wait and see. But there's some question about whether a sole practitioner would be eligible for this. Any guidance, or is your understanding that independent contractors, sole practitioners, maybe who operate with a professional corporation, but they are the sole employee, could they be eligible for this benefit? And do we have any indication as to how this 30% wage loss is being calculated?
Ryan, do you want to handle that, or would you like me to?
So I think there's two different aspects of that. So one, if we're talking about the Canada emergency benefit, I think that, and it's still getting more details, but if you're a solo or a sole proprietor, contractor, those people are covered under that. So you'd be eligible to get that $2,000 per month under those situations. I think the second part was more geared toward the new program the government has implemented, where they would cover 75% of wages, and that would be based on if there is a reduction of 30% or more. I think that was more geared towards that. And Adrian, maybe you can talk about that program, if that's where the questionnaire was going with.
Yeah, as I understand it, and I agree with Ryan, we don't have all the details on many of these things, including the federal wage subsidy program, which are supposed to come out any time. But as I understand it, the government is suggesting it's going to apply to any business, large or small. And so if a sole practitioner employs an employee, and the sole practitioner's revenues have on whatever measure the government requires us to use, have contracted by more than 30%, then on what I'm reading so far, and it could change, that sole practitioner would qualify for the wage subsidy for an employee that's impacted by that drop in revenues. That's how I'm reading it so far, but that may change in a few hours or tomorrow. We just don't know yet.
Thank you both. Some questions as well about contracts that have been signed, but work has not yet started. So articling students, for example, who have entered into agreements, but their work hasn't started yet. Summer camps that have entered into contracts, the work has not started yet. If these contracts have to be canceled, what is the effect of that? Is that just treated like any other layoff, or are there additional considerations?
Yeah, I mean, that's a really interesting one. One thing that we didn't bring up that potentially could arise is frustration of contract.
Right.
So there could be a argument to be made by employers, especially given what's going on today, that we can't hire that student or that employee or that articling student based on the COVID situation. The contract has actually been frustrated. So that may be potentially an argument that we could see being made surrounding that.
And Derek, I was going to ask you before I answer whether there are any Dentons summer articling students on the line.
I'm not.
I'm kidding.
Okay.
Before I answer, but I think Ryan is right. There is a frustration argument. I mean, I would hope, of course, just leaving aside the law, that lawyers, we're all going through this together, and to the extent that lawyers have work, that they enter into a discussion with the student and try to work something out that works for everybody, instead of just terminating the contract. I mean, I would hope that that's how we would operate collectively as lawyers at a time like this. So I would say to the students who are in that situation, humanize this. Go and chat with. I guess we're not supposed to meet face to face anymore, but have a video call with the lawyer or the firm, have a chat about it. And especially if it's a small firm that might be a little bit more flexible, be innovative, suggest different ways that you can help the firm and what you're willing to do to sacrifice and what the firm's willing to do, and try to work something out. I think instead of taking a kind of an either or approach to it, or a legal approach, this is a human issue of trying to work something out that works for everybody. And I'd really encourage you to talk to the person and try to work something out.
Thank you both. And I know we're coming up to the end of our webinar. There's still so many great questions here, but I'll try to consolidate a number of them into this one, and this will be our last one. A lot of folks are asking questions about unsafe work conditions and giving some specific examples. Some are in the healthcare context, some are in the construction context. Basically, there are concerns about what does an employee do where they feel they are in a situation where they aren't feeling safe, or they're concerned about how others are not engaging in social distancing. Any general guidance on how both employers and employees should address this question of concerns surrounding unsafe work conditions?
From the employee perspective, I always tell my clients, your health, your family's health, that's the number one important issue. And so if you feel unsafe, specifically some of those questions were related in the healthcare field and the construction field. If you feel unsafe, don't put yourself into the harm's way. I know it's difficult. People need money, need to live, have to take care of their family. But if you're sick, then you're not able to take care of your family, right? And so I think that has to be top of mind. I know with respect to the healthcare field, there was during the SARS pandemic, there is some case law out there that employees in the medical field, specifically nurses and doctors, they were allowed to refuse work if they weren't provided the proper equipment. And so I know in the news there's been a lot of talk about not having enough masks or gowns, things like that. And so there has been some case law out there on that. I'd be interested to hear Adrian's perspective on it.
Yeah, just on this one, the OHSA, Occupational Health and Safety Act, at least here in Ontario, and this varies across the country, exempt certain types of workers, particularly emergency and health workers, from the right to refuse unsafe work if the condition or the hazard is inherent in their workplace, or if they would stop working, that it would put in danger the lives of others. So that obviously applies to doctors and nurses. I agree with Ryan, though, that if they're not being provided the appropriate equipment, then that may raise a safety issue that they could refuse to work. I think what we are seeing, some employees who work in kind of the quasi-health sector who are very anxious about going in, perhaps understandably, and some organizations are now starting to struggle with not having enough people to do the work of caring for the vulnerable. So it's a real tension between protecting yourself and also the obligation that we have, particularly as Christians, to be there, especially at times of crises, for the most vulnerable people in our society. This is, again, something that I would hope that people could sit and have an honest chat with their boss, express their sincere feelings and concerns and their circumstances, and try to work something out that works for everybody, instead of people just, either employer or the employee, acting rashly and saying, you're not coming in, or I'm not coming in. Sit down. And I'm a big believer in actually sitting with somebody and working things out if you can. So this would be a time where I think you should try to do that.
Absolutely. And I think that's a great note to end on. Thank you so much, Adrian and Ryan, for your presentation, for answering those questions. Our apologies to those that had questions that we didn't get to. Maybe we'll have another webinar as some of these new programs are unraveled and unfolded, and we can answer some of your questions at a future date. But really want to extend our appreciation to you, Ryan and Adrian, and to all of you for listening. And Sarah, I'm going to hand it over to you to just share some final announcements before we close.
Thank you so much, Derek. I really appreciate both Adrian and Ryan and your insight and wisdom today.